Welcome, Professor Michael Kaye. Legal Scholar Academy is very happy to have you here. You're our first interviewee, and we're going to talk about legal education and your tremendous experience of teaching at Washburn University School of Law. Could you kindly tell us about yourself very briefly, and how did you end up at Washburn?
Well, it's an interesting story to me. I started out as a French teacher at a middle school in Cleveland, Ohio, where I grew up, and decided to go to law school. I continued teaching French while in law school, and from there I went to New York University, where I took a master's degree in international law. While in New York, I really began to feel that I wanted to be an academic. I enjoyed the classes, I enjoyed talking with the teachers, and I was stimulated by contact with the students from other countries. I continued that for 2 years more, 1 year in Europe, studying in France, and the other in New Orleans, here in the United States. Following that, I took a brief recess from the teaching environment, the academic environment, and I went to San Francisco, where I took the California bar and decided to fulfill a dream that I'd always had, which was to be a trial lawyer. And I did that for approximately 5 years or 6 years. I was a criminal defense lawyer, I was a public defender, and in 1979, after working as an associate dean at a small law school in San Francisco, I had the opportunity to come to Washburn to direct the law clinic. I felt that clinical education fit my interests very well. It was in the academy, and I was able to use the skills that I had gained in criminal defense and trial work. So I found Washburn to be a place that I felt I could develop myself further as a teacher, and also continue to hone the trial skills that I'd acquired while in practice.
Now, how long have you been teaching at Washburn?
Well, I've been here this will be in 2015, I'll have been here 36 years.
And is it all clinic teaching?
No, not at all. When I began my work as a clinician at Washburn, soon after, the opportunity to teach in the classroom and remain in the clinic came my way. And I felt that this was a splendid opportunity, another door opened for me, which was that I could go into the classroom, I could teach in a traditional academic setting, and at the same time I could pursue my interest as a clinical teacher. One thing that had sort of caught my eye was when I came to Washburn, I went to Notre Dame for an ABA seminar, and this seminar was directed to law professors who were studying to be skills teachers or clinicians. And I recalled there, Washburn sent me, I recalled there that one of the speakers said, during the day I'm practicing and I'm having interesting experiences. In the evening I go to class, and those experiences become part of the basis of my teaching. And I thought that was great. So I saw this as a perfect combination.
How would you distinguish between clinical law teaching and classroom law teaching?
The difference, there are many similarities actually, because in clinical teaching you're working with students and you're dealing with the important issues that the subject matter that they're involved with raise. Important issues may not necessarily be the ones that decide the case. These issues can be issues of what is the purpose of a particular type of statute, what is evidence, what can be used to persuade people. At the same time, in the classroom, you're also addressing similar type issues by getting students to confront facts and rules, and you try to awaken them to what they really don't know about the law and what they do know in the form of a dialogue. So the similarities are great. The differences really are that in the classroom environment is a community environment of a larger number of students in which the instructor, and I'll probably tell you this again in my view, is something like the conductor of a symphony. The class begins with a brief review of where we're at and where the instructor feels we're going to go today. That's me. I consider that sort of an overture. After that happens, I try to work with the students in a way to bring out their ideas, empower them to ask questions, respond to their questions. And as this goes on, I often feel it's very much in the nature of a symphonic experience. The clinic is not that type of experience. It's much more one-on-one and two-on-one. And that changes the dynamic.
Now, what kind of subjects do you teach in the classroom?
Well, I teach evidence. I started out with criminal procedure. Of course, that would be a favorite of mine. I teach criminal law. I teach mediation, which is a new interest of mine. And I run a trial skills program.
Now, do you have a pedagogical theory? Why do you teach, and what is it that you're trying to achieve in your classroom?
Well, that's a complex, that's a question that calls for a complex answer, really. It's hard to answer simply for me, but I would say that I believe very strongly in the value of the Socratic method. And to me, the Socratic method, which has gotten a lot of criticism from law faculty and non-law faculty over the years, to me, the Socratic method is the best way to help students think about what the law is about, think about how the law affects them and others and how it changes, and empowers them to be as smart as the instructor by giving their own analysis and in so doing engaging in what I call law creation. So this type of teaching for me is has much less of the information provision, giving information out, coverage. I try to control myself when it comes to having to succumb to the temptation to try to cover as much as possible and try to focus as much as possible on the students themselves in a collaborative manner. So Socratic teaching and collaboration with students is really my ideal.
So when you are, teaching them how to think, and they are engaged with you in almost question and answer sort of battle, do you think that what they're learning is transferable to their real law practice?
Well, I definitely think so, yes. I don't consider it a battle as much as it's a form of integration of ideas and a form of exploration. The law, to a layperson, is a body of rules which are authoritative and which have to be followed. And in the layman's eye, a lawyer has learned those rules and then can apply them. I think that's a highly oversimplified view of what law is. And I think that when students come to law school, particularly initially, they think that that's what the law is. They will be told what the law is and they will learn it and then they will go on. And I think in much of the world, this is the manner of teaching that goes on. What those others who are using the more academic approach, when those people, what they're missing is that the reality is that law is very much argument and problem solving. It's coming up with the application of concepts and rules that have been polished, changed, morphed into other rules over the centuries, really, and often change very quickly at times, to situations that perhaps were not even meant to be addressed by those rules. And it's this type of sometimes chaotic situation that lawyers address. Lawyers have to be creative, they have to think outside the box, they have to be skeptical, they have to question. The Socratic method is very well fitted to that.
No, don't you think that most of the legal disputes are settled, and therefore the settlement skills that a lawyer should have are much more important than the Socratic skills, which presuppose perhaps litigation? And I think if you use the Socratic skills in a settlement context, you think they would also work?
Well, I think that there are going to be times in any context, whether it's legal or non-legal, when a person engaged in a conversation or, as you say, a dispute with somebody else, or an effort to persuade somebody, might have to think about what is the meaning of what I'm doing, what exactly is it that the other person, that I'm thinking, knowing myself as far as what I'm trying to accomplish, enunciating that, challenging somebody who may take a view, let's say in settlement, that their position or their position is very firm, but they may not be aware of their interests, the interests that underlie those positions. And the Socratic method helps us always go below the surface. So it's a skill that's definitely not limited to litigation. In fact, the progenitor of this, Socrates, not only did not think of himself as a litigator, but he had disdain for the sophists, for those who used the skills that he was also using only for the purpose of obtaining some benefit, some monetary benefit or some material benefit.
You have started teaching mediation. Can you use Socratic's method in mediation also?
Oh,
Yeah.
absolutely. I think that in the teaching of it, it's absolutely the case, because for example, one of the principles that I've noticed in the mediation context is that students have to understand the purpose of mediation in order to choose how to proceed. Because the purpose of mediation is to facilitate, for example, the parties' efforts to reach an agreement. The litigation context is to present a case or a position to a fact finder so that they will make the decision. So the Socratic method is useful in clarifying, helping students clarify what it is they're doing and what is different about what they're doing as mediators than as litigators.
Now, as a teacher, what sort of preparation is necessary if you're advising a new teacher who has just joined the faculty? What sort of preparation is necessary in order to be an effective teacher?
Well, an effective teacher in the manner that I teach, I would say this. One, they have to make an effort to know the material, the subject matter that they've assigned, which means when it comes to cases, that they know the facts and the holdings, the basics that they're going to be using to construct the classroom, the scene of instruction, the classroom experience. But beyond that, and most importantly, they have to spend time in the hours or a day or two before class thinking about how they're going to proceed. In other words, they can't decide that because the Socratic method is a teaching method that works off the responses of the students, that they don't have to prepare. And so the Socratic teacher is thinking about how he or she will engage the material when coming to class. Once that's done, when you get to class, my experience is that I'll know how to start. In other words, it will come to me there. And as I engage with the students, the classroom method, the classroom experience will continue with me more as a guide or a conductor. So I think in order to get in that frame of mind, you have to imagine how the class is going to go, and then be ready to change once you're in the class. And you have to be relaxed, and you have to be ready to be a close observer of the students, of yourself working with the students, and of how far you're going in your coverage of material.
No, would it be safe for a new teacher actually not to use the Socratic method? Because it seems to me, as you're saying, that you need to have almost complete mastery of the materials, so that if the students are taking you in the wrong direction, you can bring them back on track without disturbing their calm. And therefore the skill that you need in order to teach kindly but Socratically at the same time would require some teaching experience.
Well, I think that when we think about the skillful teacher, all teaching methods pose challenges to new teachers. For example, lecture is a skill that's acquired and improved. But I think that as you're saying, master the material, a person who teaches in this method, for example, has certain types of questions that they're going to be asking. Some of those questions are questions for asking for some rather conventional answers. For example, what happened in the case? And the teacher will listen to the student trying to tell the facts. And let's say they should notice by way of prior preparation that the student has missed certain key facts. And the instructor will then stop them and say, wait. And this can be very unsettling to the student. You've left something out here. That's one example. Another would be the student will say, well, what is it you want me to say? Well, the instructor may really want them to say something in particular because they're trying to get them to, shall we say, analyze a certain argument, repeat a certain argument. So the types of questions that your preparation, whether you're a neophyte or a veteran teacher, is going to be able to help you to do. At another point, though, in the teaching, you may actually ask questions that you yourself don't know the answer to, and that have awakened your curiosity, or questions that the students will find unsettling because it's unlikely that they've thought about it. Now, to do this kind of work, a law professor who has had some practice experience, who's had some graduate experience, people don't teach law fresh out of law school, perhaps it has had business experience too, I think is ready to teach in this manner. I mean, you have to keep in mind that Socrates was not an educated man. And I think that what my view has been is that I've spent time talking to mechanics, for example, who understood their trade and who could, if they wanted to, engage me in questions having to do with my understanding of what was going on with my car, and I would find them very, very capable. So I think that, in answer to your question, the idea that this is a more sophisticated form of teaching that a person should not start out with but work up to, I wouldn't agree with that. I would say that you want to start, first place, it's enjoyable. It's enjoyable for students and for the instructor, even though both will feel uncomfortable at times because there are certain uncertainties that can't be hidden. But I think that, and I found that I tried different methods in my initial years of teaching, and I always came back to this one.
So why is it, if you think that the Socratic method is so effective, why is there so much criticism of it in the academy, in the law academy?
No question about it. I think that the reason for that is, on the one hand, what passes for Socratic teaching is not Socratic teaching. And that's one of the things that the people who are most severe in their criticism seem to be addressing, which is that a very unimaginative and narrow inquiry. For example, a student mentioned to me the other day that a student gone out of state to a law school and was very disappointed because the classroom was, an instructor comes in, says, what are the facts, what's the issue, what's the holding, very little else goes on, and they move to another case. For some people, that's the Socratic method. For others, others feel it's a form of humiliation. There is actually humiliation in the results of the method. People feel, I'm embarrassed. The teacher will feel embarrassed sometimes themselves, as given their own answers. But I think that what the Socratic method, when done properly, does is it helps the students to feel, yes, I fell short on this. The instructor, who, after all, in the eyes of the student, represents the legal world, the world that they want to get into. And if the instructor appears to disapprove of what they've said, they feel terrible. But if done right, the instructor manages to convey to the students that yes, you fell short, but you can learn to do this, you can learn to understand this. And the students begin to develop confidence that way. For example, in my classes, I ask students to stand up when they recite a case. We have most of our question and answers sitting down, but when they recite the facts in the case and address the issues, I ask them to stand. This initially was very unpopular with students. They didn't feel at ease. But I found that they began to enjoy it very much. It gave them confidence to stand there, go one-on-one with the instructor. And so after the first year that I did it, I decided, well, maybe I'll give them a break, I won't do it. So I started my class, and the students knew what had happened the year before. And first thing I knew, they were standing up without my even mentioning it. So I decided that I would continue to do that.
Now, in terms of scholarship, we also expect law teachers to write. Do you think there is any relationship between teaching and writing?
Well, there has to be, because by engaging in legal scholarship, you're confronting the material that you work with in simply another medium. And you're articulating ideas, and you're putting ideas out into the public sphere. Not only that, but writing allows you to go beyond what you're doing in the classroom. For example, I was interested in law and psychology, and I did some surveys having to do with municipal court judges' attitudes toward what they were doing toward a particular type of legal proceeding. I did a simulation with a psychologist on the topic of psychological effects of traffic roadblocks, anticipating an opinion by the U.S. Supreme Court on checkpoints. I felt that I don't use that information necessarily in my teaching, though I sometimes mention it, but only occasionally. But I think that using your mind through discussion, through writing, through direct teaching, all of that is training to be a good professor.
Do you think there's an essential link, or it's okay to write and teach? Because there are examples of great teachers who, for some reason, for example, Socrates did not write, and he was the greatest teacher. A lot of other examples are also available.
Yes.
So is there a essential relationship between the two?
No, I don't think so. I don't think there's any more essential relationship between that and teaching than there is between having a particular teaching method in the classroom. I think that what really matters is to find your own way as an instructor to develop those qualities of candor, of skill in articulating your thoughts, of having concern for the students who are learning with you and from you, and also deepening your understanding of what it is you're teaching. And I think that if we look at the academy itself, we see a wide range of experiences and preferences among teachers. And it is so diverse that I think that it's hard to say that there is a one-on-one correlation at all times between one method and academic teaching success.
Now, would you say that a law teacher should have a viewpoint in class? For example, let's say that you believe in critical race theory and you feel that most laws are they're not race neutral. Or let's say that you are a woman and you feel that many laws are gender biased. And therefore, after studying law and after writing, you develop this jurisprudential viewpoint. Do you think a good teacher will teach from a personal commitment to a jurisprudential viewpoint, or would he not, be able to impose this on the students?
Well, I think a teacher is entitled to express his own viewpoint vis-a-vis the material in class, but it has to be done thoughtfully because of the difference in power, at least that, between the faculty member and the students. The students see the instructor differently than they see each other. So if a student raises an issue and expresses an opinion or a viewpoint, students will respond to that in different ways, but when the instructor does it, students may get a mixed message. Perhaps I better agree with the instructor, I'll not do well in the course, or maybe my opinion won't count because it's in conflict with what the instructor says. This issue goes throughout higher education and secondary education too, I'll bet. So it's not limited to law schools. And I think that I think there'll be a lot of disagreement about it. But my own personal view would be that the instructor doesn't need to hide their opinions. But they have to realize that their opinions have to relate to the material. Their opinions should be, if they're going to put their opinion out there, they're going to have to accept scrutiny from the students. And they have to communicate to the students that if they're going to make their opinions known, those opinions are fair game for the students if they want to argue with the instructor about it or even reject them. I think that those are the types of things that a good teacher has to think about.
So there's no harm in teaching, particularly constitutional law, for example, from a strong ideological viewpoint.
I think that if your goal, it depends, well, I don't think so. I don't think that's a problem. But I think that in order to answer that question, you have to say yes, as long as, and then you have to talk about how that's going to be done and how free the students are going to be to accept or reject the professor's own view. Because the purpose of that class is not to teach the professor's view. It's to give the students the opportunity to make what they want to make of the law. And so I think it's something that I think all instructors have views that are communicated one way or another in the classroom. Though some may go out of their way to make sure that their own viewpoint isn't known. But I think that realistically, students who are, after all, college graduates, they're in the world, know that everybody has a viewpoint. And I think there are students who feel much more comfortable knowing what the instructor's viewpoint is. But the instructor is not teaching their viewpoint as the subject matter of the course.
Now, slightly changing the topic, how would you say that the legal education in the United States has changed over the, decades? I mean,
since I've been teaching?
Is there a big change?
Well, yes, there is a big change. I definitely think so. And I can give you an example of it, what you asked, because yesterday I was sitting in a coffee house, and 3 men sat down at the table next to me, and they'd reserved this table for a discussion. And one was a retired judge. I knew who he was. And the other two were also retired, and they were talking about law. And one of them had served in a jury. But they then asked him, what is teaching, has law teaching changed since you were there, since you went to law school? And the judge said, well, yes, it has changed, he said. He said that they let a lot of people in when he went to law school, which would have been in the early 70s, I think, and then they failed a lot of them out. And one of the other people said, well, wasn't it much like Paper Chase, with Kingsfield? And they agreed that it was. A man came to visit my classroom, a lawyer, and with his daughter the other week, and he'd been to other classrooms in our law school, and he spoke to me afterwards and he said, law school teaching has changed quite a bit since he went to law school. And he had graduated in, I believe it was the early 79. And he said that the difference was that instructors were much nicer to the students than they were in his time. I think that the relationship between teacher and student in many good law schools has definitely changed. And teachers are more open, teaching methods have broadened, clinical education has brought a concern for skills teaching and experiential learning to the law schools. But I think that just like the law itself, the centrality of text has remained in the law school. We're like the judicial process, which is that we've put new wine into old bottles, you might say. We've kept a lot and changed a lot.
Now, would you say that it's a good teacher is a popular teacher?
Usually, yes, I think so. The reason I say usually is because I think students, what is a good teacher, of course? If the good teacher, by that you mean a demanding teacher, a teacher who has a high expectations, who tries to bring the students to a different level of understanding, which may be uncomfortable. I think there will be students who don't appreciate that. And as long as the good teacher isn't rude or perhaps eccentric in a way that students might be uncomfortable with, I think generally those people will be popular. Now, there are students who I think might pass judgment on a good teacher for other reasons, may not like that style of teaching. But I think overall, students recognize when they're learning, and students in law school want to learn and want to be lawyers. I mean, they take it much more seriously than undergraduates do, I think. So I think generally the answer would be yes.
But it's possible that a great teacher may not be very popular with the students.
Well, I mean, it's possible, I think, but I would have to stand by my belief that, generally speaking, what I've learned about the law students, and of course now my experience has only been in teaching in 3 law schools, but my experience over the years has been that law school is nowadays has some entertainment values that it didn't have before. In other words, students get involved in role playing and that sort of thing. But no, I think that generally speaking, students want to learn if they feel they are learning, even if they feel that the instructors made them uncomfortable at times. Appreciate it. But I think in all teaching, there will be times when there's a disconnect between the learner and the instructor. But I think it's much more seldom in the law teaching I've observed.
Legal education in American schools is heavily influenced by the litigation model. I think many first-year classes are particularly designed from the viewpoint that people are going to practice law in the United States, and maybe before state courts. And the underemphasis on alternative dispute resolution and understanding the law from a transactional viewpoint rather than litigation viewpoint. These are some of the things that are now entering legal education. So if you teach contracts from a litigation viewpoint, it's going to be different than if you teach contracts from a transactional viewpoint. So do you think legal education should now incorporate the transactional viewpoint of law?
Well, first of all, the alternative dispute resolution revolution in legal teaching started a long time ago. There are case books now that date from the 70s, just as clinical education dates from like 1970. So I think that the entry into the academy of the alternative dispute resolution model is definitely there. I think that I don't agree at all that we teach a litigation model. I think that the reason, and it goes back to Langdell, the reason that we use cases is because they're an excellent way to study legal thinking at work in a real context. And that's what's being taught in those courses that come out of torts and criminal law and contracts, for example. I don't think that teaching legal thinking from the point of view of, or through cases, I should say, through case study, which of course is studying disputes that have gone to court. You can teach just as much about legal thinking by using other models. Not always as successfully, I suppose, but because in the cases it's explicit. When you talk about alternative dispute resolution, you're talking about a different dispute resolution process that involves something outside the rules of doctrine, I think, quite often. And if that's the case, there's a lot less of jurisprudential analysis. So I think you need both.
Now, if you look at a dispute in the real life, you will see that this dispute has legal dimension to it, but the dispute may also have economic dimension to it, emotional dimension to it, a sociological dimension to it. So don't you think an overemphasis on legal rules and doctrine and legal thinking might cut out very important dimensions of the dispute, and parties would be very unhappy with the legal outcomes?
Well, I think that what you're asking is, should we include in our teaching consideration of these other attributes of disputes? And I agree with you that we should. And if you look at case books, you do see that. You see, for example, in the criminal procedure case book, race and law is one of the chapters. You'll see economic discussion in other case books and in contracts case books. In evidence case books, you'll see studies of how people process information and the psychology of what's going on. And I think that, so there are any number of other perspectives that should be addressed. Now, the curriculum itself can help with this because, for example, we have in our school the perspectives courses. In other words, the idea of giving people an opportunity to see a variety of perspectives on the law. There may be specialized courses on law and economics. But I think that at the same time, we are training lawyers, and that there are certain things that we should emphasize when it comes to dealing with rules, the application of rules, analogy, argument, persuasion, that still have a place in our teaching, an important place.
But with the rise of legal positivism, it seems like law was made autonomous, and there was some understanding that law as an autonomous discipline can resolve disputes adequately to the satisfaction of the parties, and therefore the non-legal considerations should not muddle the autonomy of law. Is that still a valid jurisprudential model in teaching?
Well, I think that what positivism does is recognizes the nature of law as a specific cultural artifact. In other words, that if it gives us the reality of what the use of rules is and the nature of rules. And I don't like, for example, H.L.A. Hart's concept of law would be an example of it. I don't think that that's that effort includes within it a disregard for the other aspects of practice. You know, you can't put everything into law teaching that a student who becomes a lawyer will then confront in practice. The world of practice is very complex and changing, and students should leave law school convinced that they will be lifetime learners, because most of what lawyers know they learn in practice. And so what law school provides them with is a disciplined, inquiring mind that has some familiarity with certain basic tenets that are peculiar to law, and an understanding that the boundaries of the law and the subject matter of the law are not fixed.
Now, given the fact that more than 90% cases are settled in civil litigation, and similarly they are settled in criminal law also,
right,
called plea bargaining. Now, would you say that in light of this great statistical information of settlement, law as a discipline has failed as a method of dispute resolution, because it doesn't go all the way to the end?
Well, I mean, I think what you might say, ask would you agree with this? It could be that the adversary method as how shall I say it, as expressed by the adversary system, the trial, the judge and the jury, or very few cases now go to juries really. Most people, there are many, many more bench trials. Whether that has been a failure. I think the answer is no, it hasn't. There are still times when that is the best way to resolve a dispute. There are certain types of cases in which people want the conscience of the community expressed by a jury. I don't think that the adversary, the legal teaching and focus on the nature of law and argument and persuasion, I don't think any of that's failed. In fact, in settlement, in negotiation, in plea bargaining, many of the same skills are used. In other words, the same skills of legal analysis, the same skills of persuasion based on understanding the facts as well as the law, and in mediation also, where the parties, lawyers have a place in mediation. It's called mediation advocacy, where lawyers also advocate on behalf of their clients vis-a-vis the mediator. So I don't think that any of this is a failure. I think the real problem in our justice system, whether it's civil or criminal, is that it hasn't dealt well with the power imbalance that exists in our society. And that is a fundamental failure, because the law is intended to mediate between the powerful and the less powerful, and the powerful and the other powerful. And that's why torts would be a great example of it. And that I think we have had failure.
Would you also say that judges, to what extent judges set aside their personal views and decide cases within the autonomy of law?
Well, it depends on what you mean by the autonomy of law. because I think that what we're looking for in judges and other fact finders is that they'll be committed to the values of fairness that underlie the legal system, at least in theory, and that they won't allow their biases to distort their reasoning and their judgment. When it comes to jurors, we have a great many procedures in place to try to shield jurors from their own biases, the rules of evidence, the rules of procedure. But you know, the problem is, when you talk about judges, judges have a freedom to act with limited review. And the selection of judges, of course, is often a political decision. How judges are chosen varies among the states, and I think that judges who have so much power have to be on their toes and aware of the harm they can do. They have to be mindful of that. That is a temptation.
Now, when we look at Supreme Court cases, we can almost predict in most cases how the judges, the 9 judges, are going to come out on the issues, because some are committed to conservative interpretation of the Constitution, others are more liberal, open. So they are dealing with a statute, and the same statute, and 4 judges will come up with one viewpoint, and the 5 judges will come up with the opposite viewpoint regarding the same statute. So if law is really decisive, how can it allow 9 judges to have opposite understanding of the same provisions of law?
Well, just as the way in which some jurors will acquit and some jurors will convict. Within the bounds of the law, there's room for disagreement. And yes, we know the Supreme Court, for example, is under scrutiny, of course, by the public. It's the highest profile court in the land. And we know a lot about the judges the longer they serve, and even before they get on the bench, we've heard a good deal about them. But what we find out is that they're not always as predictable as we think. And when they diverge in their views, what they're expressing is really, I think, the way in which a lawyer applies the law. In other words, there isn't only a single interpretation to things, even if they're put in words, even if they're written in a statute that's intended to be clear. There are cases which are easy to answer. In other words, a burglary charge. If burglary means entering a home with the intention to commit a felony or theft, and somebody enters a house, pulls out a gun, and takes money, well, that's going to be a burglary. And there's nobody, no matter what their political stripe, is going to say that wasn't a burglary. On the other hand, the cases that reach the U.S. Supreme Court are those that are most highly contested. And the Supreme Court takes the cases that have the most national importance. Of course, they also take cases as the top court in the federal system, but they also grant review of state cases in which there's great public interest. These cases, such as many speech cases, cases in dealing with personal rights of privacy, like abortion cases, these are cases that aren't going to be resolved by looking at the statute and saying, well, that's what it says. Now, the public may think that, but that's the problem. There's an inner knowledge of the law that the public is not, an inside knowledge that the public is not privy to. Law school teaches students to have that inside knowledge.
No, then are we saying that law is clear regarding little matters, but when it's really important to a nation, an issue is very significant to the entire nation, law simply does not provide any guidance, and the most experienced judges are divided, horribly divided, and and therefore law has ceased to provide any guidance.
No, I don't think so. I mean, I think that the divergence of opinion doesn't mean the law doesn't provide guidance, but it does give choice. And I don't think it's a matter of the law on small matters being clear. There are plenty of cases, important and not important, where the law may very well be very clearly written. But if you take something like disorderly conduct, stopping and frisking people, these little matters have gone to the U.S. Supreme Court and have found the judges to be divided there also. I think the question about all this has to do with values. Lawyers' values, judges' values, and our community's values. And these values come into play when we interpret cases and statutes. And they often provide the rule of decision. And the law makes room for that. And what the law requires, though, what our process requires, is that these values be appropriately applied. And that's the difficulty as well as the interesting part of being a lawyer.
Well, very interesting. I have two more questions to ask. We're running out of time. Thank you very, very much. It has been very enjoyable. The first question is that is it okay for a law teacher to teach legal relativity? For example, you could say to the students, well, it depends what your client's interest is. And two attorneys dealing with the same dispute, dealing with the same law, could have different viewpoints, emphasizing facts slightly differently and bending the law slightly differently, even though they're dealing with the same law. So at the end of the day, it seems like legal relativity rather than a firm legal guidance is the way we are teaching to the students.
Well, I think that what we're teaching is not the truth. We don't teach the truth. And we're not those who are supposed to know the truth. What we're doing is introducing people to a process that is an extremely important part of any civilized society, which is the creation, the interpretation, the application of the law. They know, students will know from the beginning, that there are a very limited number of clear answers, and that in the process of applying the law, especially where there's conflict, as opposed to even in a negotiated transaction, that different viewpoints will be sought to be, shall we say, victorious. In other words, people will try to win. People will try to get their own way. People will be very adversarial. When it comes to alternative dispute resolution, we try to directly create a situation where it's integrated, where people are trying to work together to solve a problem. But they're all going to bring different viewpoints to it, and if they've got lawyers, their lawyers will be the ones who articulate those different viewpoints. I think that's in the nature of the law, and I'm glad it is. And I'm glad we're teaching it that way.
The last question, Professor Kaye, how would you describe a good day in teaching for yourself?
Well, it certainly would have to do with talking to colleagues and feeling welcome and feeling the enjoyment of collegial discussion. But I would say a good day for me is to walk out of the classroom feeling that I had indeed conducted the symphony, and that I and the students learned a lot about something that we may not have completely understood, but that it was a symphonic day, and that really is what I enjoy.
Thank you very, very much. Appreciate that.
Thank you for asking.